See the numbers climbing quickly there, gentlemen. For those joining us, we have over 250 registrants, and I see the number climbing 118, and it keeps climbing. So we'll give it just another second here before we start. Okay. I've got 1 o'clock Eastern time. Let's go ahead and begin. So hello, everyone, and welcome to today's 1-hour accredited and highly informative webinar, Workplace Drug Testing in the Era of Marijuana, brought to you by ArcPoint Labs in partnership with Drug Screening Compliance Institute. My name is Ryan West, Director of Corporate Training for ArcPoint Labs, Certified Employee Assistance Professional, Substance Abuse Professional, and your host for today's webinar. I have 5 brief but important announcements before I introduce our speakers today, and to ensure I don't miss any of the details, you'll see me referencing my notes. First, while only 3 people are leading this webinar today, mostly 2, there are a lot of people working behind the scenes to make events like this possible. So I want to say thank you to every ArcPoint team member, both corporate staff and our lab owners, for all of their continued help and support. Second, this webinar is accredited for credentialed HR professionals. Activity IDs for both HRCI and SHRM credential holders will be shared at the end of the webinar, so stay tuned. Third, your opinion matters. I'm going to post a survey link in the chat at the end of the presentation, and would greatly appreciate each of you taking 1 to 2 minutes to give us some anonymous feedback. Fourth, this webinar is being recorded. A link to the recording along with a PDF copy of the slide deck is scheduled to be emailed to all registrants by week's end. However, a copy of the certificate will be emailed to all attendees by the end of today. No doubt today's presentation is going to be chock full of helpful information for every listener. However, 1 hour simply is not enough time to deep dive into the changing legal landscape of cannabis/marijuana for every state, local jurisdiction. If you're interested in an up-to-date marijuana state law guide for your particular state or states in which you operate your business, stay tuned until the end of the webinar for instructions on how to obtain that guide or those guides. And finally, both the chat and Q&A functions are available for everyone to engage with me, our speakers, and one another. This is a cheesy pun, but so our presenters don't have to weed through the chat to find your questions. Please submit any questions you have using the Q&A functions. Our presenters may respond to your questions real time. They may wait till the end. Completely their call, and Nick and Bill can speak to this a little bit more. Please use the chat function to offer commentary, any insights that you may have and want to share with the entire room. And with that, it is my pleasure to introduce our expert speakers today, Bill Judge and Nick Hartman. Bill is an attorney with over 35 years of experience in the workplace drug and alcohol testing industry. He has written and edited numerous articles and publications, and regularly shares his industry expertise and thought leadership at local, regional, and national speaking events. Nick is an accredited drug screening industry consultant and advisor who has built, implemented, and managed drug-free workplace programs for thousands of employers across the United States and abroad for more than 17 years. Gentlemen, thank you so much for sharing your time and expertise with all of us today and for your continued partnership with ArcPoint Labs. Take it away.
Thanks, Ryan. Appreciate it very much. And thanks to the ArcPoint Labs team for having us today. And a special thank you to all of our attendees taking time out of their busy days to join us for today's presentation. Our agenda today, we'll hope to get through all this and have some time for Q&A, but we're going to provide you with an overview of the marijuana laws that are fast evolving. In fact, we were just working on a new revision this morning. We're going to touch on some of the latest data on substance use and why that's important to what we do each and every day with workplace drug and alcohol testing. We're going to talk about some new legal limitations on employers, how the trend of these laws continue to start affording employees more rights. And then, of course, we'll end with some guidance and action items to make sure you guys have all the tips and tricks that you need to be successful and compliant. And as Ryan mentioned, we'll have some time at the end for Q&A. Please make sure you're submitting your questions in the Q&A box. If there's anything hot, we'll grab in the presentation. Otherwise, we'll address those at the end. And of course, if we happen to run out of time, we'll make sure we follow up on all the questions that are submitted. Now, while Bill is an attorney, as you heard, we are not a law firm. The information that we're presenting today, of course, is for general educational purposes only. As you can imagine, everyone's situation is different. So we certainly advise you to seek legal advice prior to taking any adverse action based off of today's information. So with that, we'll dive right into where we stand today, specific to marijuana laws. As of right now, there are 37 states, Washington, D.C., and a few U.S. territories that authorize the medical use of marijuana. Of course, this is for various different medical reasons. Some very, very specific. Some states offer more general qualifications. And we bring this up obviously because there is an importance here, as we'll talk about in today's presentation, where some of these states' laws dramatically impact employer workplace testing programs and the rights for medical marijuana users. So we'll touch on more of that detail here in a moment. Also, there are currently 23 states, Washington, D.C., and again, a few U.S. territories that authorize the adult use of marijuana. Where in previous presentations, we were happy to say that these laws didn't impact the workplace. That certainly has changed and has started to change pretty dramatically, especially as it relates to how you can test, who you can test, when testing can take place, if testing can take place. And we'll dive into some more of those details in today's presentation. But this chart continues to get colored out. And then add to that the 18 states that currently have some kind of authorization for the medical use of cannabidiol or CBD, typically in oil, in an oil format. You'll notice on the chart here, we have a couple of highlights, and Bill, you could probably speak to these, but Virginia was very, very unique in being the only state, according to our records, that has a CBD law that impacts the workplace. Affording rights to those that lawfully use cannabidiol medically, which is interesting because it affords them rights from being terminated. But in workplace drug and alcohol testing today, we don't even screen for CBD. We screen for THC, cannabis, marijuana, whatever you want to call it. So it was kind of interesting, that concept. And Bill, you want to elaborate real quick and touch on Iowa?
The only thing I wanted to mention is Iowa is shaded there, as you can see. And the reason for that is that they refer to their statute as a medical marijuana law, but in fact, it is a low dose THC statute, which essentially means cannabis or cannabidiol as well. So just a little reference there so people don't get confused.
Thanks. So if you put the whole big picture together, you can see here that there is pretty much every employer out there is impacted by workplace drug and alcohol testing regulations specific to marijuana. All but 2 states now have some form of marijuana or cannabidiol law. And of course, it's no surprise to anybody joining us today that we see the trend of legalization that'll undoubtedly continue. I'm sure this map will start to get filled out and work to an all green status over time. It's almost inevitable. And we also are dealing with another round, the potential of federal legalization, which could drive some of this trend as well. So why are we talking about this today? Why are we all here? Why are we talking about marijuana? Well, the biggest thing here we wanted to touch on is some data, give you some statistics. We can say all day long that drug-free workplace programs work and they make for a safer workplace and they have all kinds of tangible and financial benefits for employers. But we got to look at the root issue. And the data you're seeing on the screen right now is from our friends at Quest Diagnostics. Every single year, Quest brings out a drug testing index, data on workplace drug and alcohol testing. And Bill, correct me if I'm wrong, I think they analyze something like 8 or 9 million drug tests a year.
Yeah, I think they did 11 million here this last time, but incredibly valuable information.
That's right. I mean, it's the facts, right? We're not making anything up. We're unbiased in our conversation by just looking at the data. So the overall drug testing positivity rate in 2022 reached a 20-year high at 4.6%. So 4.6, nearly 5% of all drug tests conducted came back positive. And this is just drug test positivity all overall for all substances. If you look at the marijuana drug testing positivities in the general workforce, they increased more than 53% over the last 5 years. Again, in line with the trend that we're seeing that more states are adopting these laws, allowing medical and adult use, and more people are using the substance. Now, I think the biggest data point we can get here is the conversation that Bill and I deal with on a daily basis with all of our clients is whether we test for marijuana or not, and whether or not we test for it pre-hire. And that conversation is a difficult one. Obviously, it's complex, and there's a different answer for every different employer out there because the situation is different. But simply not screening for marijuana pre-hire doesn't alleviate the issue, doesn't hide it, doesn't throw it away, because you see here that marijuana positivities for post-accident tests increased by more than 200% from 2012 to 2022. And that's pretty alarming, actually, because we don't see post-accident testing show that kind of an increase typically. Typically, it stays pretty steady. So again, I think this is a caveat to some employers electing not to screen for marijuana pre-hire. That problem just moves itself over to the post-hire stance, right, Bill?
It's going to show up someplace. So if you decide not to do it pre-hire, then you're likely to see it post-accident or reasonable suspicion, but it's likely to show up someplace.
Yeah. So a question came in that said, how likely are the post-accidents actually caused by the influence of marijuana rather than just being found in a post-accident drug test? And that's actually a great question.
Yeah.
Because you don't really know, right? And the fact that we're screening, for the most part, screening via urine, you have that longer detection time period. So you may be catching someone who used over the weekend and had an accident on a Wednesday or Thursday and still tested positive for marijuana. So unfortunately, the science isn't there for us to be finite, to pinpoint this to marijuana at all. But using Quest's data here just shows that there's an alarming trend with events that were collected as a post-accident test that did test positive for marijuana. Here's another one. With states that authorize the legal adult use of marijuana, the positivity rate increased more than 118%. And in states with authorizing the medical use of marijuana, that rate increased by just about 70% against the same time period, 2012 to 2020. And Bill loves this stat, but in states with no legalized use of marijuana, the positivity rate increased nearly 60%. Again,
not a surprise, really.
Yeah, no, not really a surprise. What is kind of surprising, and something again we don't really see very often, is the positivity rate for DOT regulated testing programs is showing an increase, which again is atypical. It usually stays pretty flat. Right. And marijuana, we're not just picking on marijuana or cannabis in this conversation. The positivity rates shown by Quest are up for both amphetamines and cocaine use as well. And as we all know, during the pandemic, alcohol sales and legal marijuana sales spiked dramatically. We saw some pretty wild data over the pandemic on how Americans were self-medicating during the pandemic. And this may be a result of that, or a hangover from that. So we're going to turn it over to Bill. We're going to dive into some state specifics. But Bill, do you want to start us off at the federal level first, just to make sure everybody knows that we're going to dive into state law, but obviously federal law trumps those?
Yeah, absolutely. What we go into mostly in this presentation are the specifics of states' laws. However, those of you who have federally regulated employees have to know that because marijuana remains a Schedule I drug under the Controlled Substances Act, federal agencies must follow that, and therefore the medical review officers will not be allowed to use the fact that marijuana use is legal in a particular state as an excuse to call a positive marijuana test in the laboratory a negative. won't happen on the federal level, whether it's DOT, whether it's federal contractors, what have you. On the federal level, there is no excuse for a marijuana positive.
Yeah. Yeah, marijuana is still a Schedule I drug under federal law. Again, so whether you are using, whether you're prescribed medical marijuana by a physician, or whether you use marijuana lawfully in states that allow it, if you are regulated at a federal level, you are certainly jeopardizing your job. And,
Yeah, and what you see, I'm sorry, Nick.
go
What
ahead.
you see there are copies of the DOT position papers, which you can download yourself off of the DOT website.
Yeah, good point, Bill. Thanks. So let's talk, Bill, about some states that provide employer protections, the good news on marijuana legalization thus far.
Yeah, what we want to make certain everybody understands is that every state is different. I mean, there are a lot of commonalities, but you've got to look at the very specific language of each state's laws, okay? But these 20 states, the law specifies that employers need not accommodate the use or an employee being under the influence of marijuana at work. That's critical. Now, I would also point out to you that we didn't get the chance to change the slide here this morning, but Minnesota can be added to that position there as well. So there are actually 21 states that indicate that employers need not accommodate use or being under the influence of marijuana at work. Take a look, again, the specifics of states' laws, Illinois, Ohio, Pennsylvania, they're very employer friendly. We can't say the same thing about Massachusetts, Nevada, and New York. They are certainly not employer friendly.
Yeah, and that one big point to clarify here is that you're going to hear us talk about state laws as it relates to regulations and statutes, but there's also other things like human rights laws or disability discrimination laws that we're going to talk about. And one note I have in here on medical marijuana, there's some states that dictate that employer must engage in an interactive conversation with that medical marijuana using employee to make sure that their underlying medical conditions can be safely accommodated before they take any adverse action, and not just base it off of a positive test for marijuana. So we'll touch on more of that as we go through this
and let me point out to you that that's a great point, Nick. Nevada and New York specifically indicate either that the medical marijuana patient is considered a disabled person entitled to all the rights under the state law, or like in Nevada, it says that you need not accommodate them. However, you must consider the underlying medical condition for that employee before you take adverse action. Again, the specifics of each state are important. Okay, in these 15 states, an employer is authorized to act if an employee is found to be using or under the influence of marijuana at work. So if you're in one of those 15 states, you can act.
So now the bugaboo of the conversation, which we see the list growing on this, is employer limitations. Employers should take caution and from a policy, procedure, and job description standpoint. So Bill, let's cover some of our top legal limitations.
Yeah, one of the recent trends in some states and municipalities are the limitations or prohibitions even of employers taking adverse action against an employee who uses off-duty. Now, there's a lot of distinctions that have to be looked at in terms of the state-by-state definitions of what that actually means, what a permitted lawful product is, lawful activity, and all of the issues that relate to this before you can take action. But we are definitely seeing a trend, an increased trend, like for instance, Minnesota's law that just was recently passed, and in some portions of the law go into effect August 1st. The employer is not permitted to take action against an employee who uses a lawful consumable product off duty. So you got to be careful.
Yeah. So again, those details matter. They're going to impact who you can test, why you can test, when you can test, what disciplines can be imposed. It's a lot of legal jargon, but we try to do our best to take that legalese and make it into digestible layman terms and applicable to your workplace testing programs. But we're also seeing a trend, Bill, in states that are passing laws, where I'm sitting here in Washington State and also in California, effective the first year. Both states will prohibit employers from some degree from screening for marijuana, or what they refer to as non-impairing metabolites of cannabis. Can you touch on the science and how that works? We're going to get a quick science lesson from a quick science lesson from
Yeah,
a lawyer.
well, take it for what it's worth. I'm a lawyer, so I mean, I'm not a scientist, but I was dumb enough to own a laboratory for a while. So take that into consideration. What people have to understand is that when we're dealing with some of these new laws, like California and Washington, and actually Connecticut has had the law for some time. You have to understand how marijuana breaks down in the system. When you smoke cannabis, it breaks down first to delta-9 tetrahydrocannabinoid, okay? Then within a matter of hours, as you can see there, studies show within 1 to 8 hours, it breaks down further into what's called hydroxy-THC. The hydroxy-THC then breaks down within, again, a matter of hours, between 2 and 12 hours, into a substance or a metabolite known as carboxy-THC. Okay, why is this important? Well, because those states' laws, and we're seeing a trend toward it, are requiring that employers can only act if they can identify impairing substances or psychoactive impairing substances of cannabis. So that means that you can only act if you find delta-9 or hydroxy. Okay, well, they're gone within a matter of hours. And what our system has been set up since the late 1980s to test for is carboxy THC, which is a non-impairing substance. So if you identify carboxy THC in California or Washington or Connecticut, you can't take employment action because that would be a violation of the law.
Yeah, that's a great point. So obviously detection times are going to be incredibly critical, and so is this method that you're using for screening for drugs of abuse. And you're going to hear throughout our conversation, we're big proponents of oral fluid testing. There's definitely catching on in the industry, and we'll certainly start taking market share from urine drug testing, just because of the sole benefits that you get from oral fluid testing, which we can do a whole presentation on that in of itself. But you'll hear that the detection time period is far more short and reasonable to what you're looking for. And I guess it kind of depends on when you utilize it. But marijuana, THC specifically, is a fat soluble drug. That carboxy THC could stay in someone's body for several days or several weeks, depending on how frequent of a user or heavy of a user you are. So again, when you talk about not discriminating against the lawful use of off duty of these products, you got to consider the method that you're using to screen for these. So more to come on that. Bill, let's talk about, so we talked about California and Washington in 2024. California's law has a small safety sensitive carve out for the construction industry. Washington law has a little bit more general safety sensitive carve out for positions that substance use could cause death. But anything you want to elaborate on Connecticut or other states here?
Yeah, it's just important for employers to make certain that you have a conversation with your providers. I know that ArcPoint is very in tune and aware of this, so that you make sure you're in compliance with these states' rules.
Yeah. So Connecticut, again, if you have reasonable suspicion, or if it's post-injury, or if it's randoms, there's some exceptions here. But again, every single state law differs. And it's becoming very, very complicated to stay abreast of all those, especially for employers that operate in multiple states, trying to keep their policy together, their procedures together that align and comply with these laws.
Absolutely. And not only that, Nick, I'm sorry to jump on you there, but it's also important for employers to realize that we're focused here on the marijuana statutes and the marijuana rules, but you have to combine these and mesh them with the existing states' drug testing rules. or the state's disability discrimination laws, because they all have to function together.
Yeah, this is, I mean, inclusive to our conversation on marijuana today, there's more than 700 different state-specific laws and well over 20,000 case law to consider as far as what you can and can't do, when and how you test, all the rest of that stuff. But again,
Exactly.
our advice here is to work with your providers, work with your laboratories to make sure that if you continue screening for marijuana and you're in these states that are limiting testing for non-impairing metabolites of cannabis, that you are set up for success in that respect.
Exactly. And let's also look at the fact that in these 11 states, a positive drug test alone by statute is not proof of being under the influence. And by the way, this is a growing trend too. It wasn't long ago that map showed only 5 states.
Yeah, it's and it'll continue to grow. This map will continue to fill out. So they're specifically saying that a positive drug test alone isn't under the influence. And Bill, how can we tell if someone's under the influence of THC?
Well, today you can't with a test result. Thank you, Nick, for that softball. But the closest thing we have to being able to fall within those time limits that we talked about with the Delta 9 and the hydroxy THC, the closest thing you've got is oral fluid testing.
Yeah. And there was the other thing that we want to suggest here and highly promote is reasonable suspicion training for your supervisors and managers. Yes. If you have a positive drug test and you went through the process previous to testing and determined that there were likely signs and symptoms of drug use or substance use that you documented and maybe even corroborated with another trained supervisor or manager, you have a far stronger case of terminating that employee versus just having a positive drug test alone.
Absolutely. There was a recent court decision in Arizona, and as you can see, Arizona is one of the 11 states where a positive test alone does not indicate being under the influence. And the employer in this particular case took action and said to the court, yes, we took action based on the test alone. You could hear from, almost read between the lines, the court was begging them to see something else. And essentially the court went into a long explanation of suggesting that in addition to the positive test, you should show signs and symptoms of drug use. Well, what the court was describing was what we all know essentially as the description of reasonable suspicion.
Yep. So
a drug test positive plus suspicion, evidence of suspicion, that might do it for you.
It's I'm a little bit biased because we deliver the training ourselves and along with our partners, but it simply is the best investment you can make in your workplace for a sound drug and alcohol testing workplace program by providing that training to your management staff. Reasonable
suspicion is becoming increasingly important in workplace drug testing these days with the marijuana issue. Okay, in these 6 states, as well as New York City and Philadelphia, pre-employment cannabis testing is limited or prohibited. There are, in fact, safety-sensitive exclusions or exceptions to that rule.
Yeah. So again, it's going to depend because some of those safety-sensitive exemptions are incredibly specific to specific industries or job types. Some are more general, where safety could be jeopardized by workplace substance use. So again, it depends on what state you're in and what the legalese is and making sure that your policy and procedures comply with the letter of the law.
Absolutely. And what I love about that Arizona law, by the way, is the fact that it leaves a decision-making to the employers as to what safety sensitive is, as opposed to saying, okay, here's what safety sensitive is. In Arizona, at least, they leave it to the employer to tell.
Which I think is a benefit, right? So the employer knows their workplace better than anybody else, but it comes down to how well they document the essential functions of the job, which we're going to talk about towards the end here.
That's exactly.
Job descriptions are going to play an incredibly crucial role going forward to justify an employer taking an exemption of these laws.
Anti-discrimination sections specifically to deal with medical marijuana Again, now we're talking about medical marijuana, not adult use. The law in these 15 states plus Washington, D.C. allow employers may not indicate that employers may not discriminate against an individual solely because of their status as an authorized medical marijuana patient. In New York, medical marijuana patients by statute are defined as disabled individuals. That means that they're entitled to all the protections under Article 15 of New York's human rights law. So what that means, Nick mentioned it a few minutes ago, before you take action, you have to sit down and have a conversation with them, the interactive conversation as we all know it, before you take action to indicate that they can or cannot do that job.
And this is not the only state. New York's not the only state. There's several, but even in, like, I think it was Connecticut, Bill, there was a case where someone sued under the medical marijuana law against their employer, and the court pretty much gave them free legal advice to say, no, you can't sue under the medical marijuana law. You have no right there, but you can take your lawsuit and sue them under the state's human rights laws because you have a case.
Exactly right. Yeah, it was actually Massachusetts. I thought that was a wonderful decision.
That's right.
Like,
That's right.
hey, you can't sue over here, but you can go sue over here. It's like, wait a minute.
So what about some more off-duty protections?
Well,
Bill?
off-duty protection of marijuana users is becoming the trend. It's something that you have to be very, very careful about. And these are a number of states where the law protects off-duty use of marijuana users. And of course, you can see a long list there, which is growing. And then the long list of municipalities, typically dealing obviously with the public works, public employees. I almost said public works employees. I've got a tree to be removed out front. Public employees in these particular municipalities.
I think I noticed a typo there. We made up St. Louis, Ohio. That's a funny one.
Yeah, that's not. Yeah, St. Louis is still in Missouri.
It's still in Missouri. Okay, good.
Yeah, yeah.
But
Missouri
I want to talk
or
about
Missouri.
New Jersey real quick. So New Jersey
Yeah.
created a law and caused quite the chaos, I guess is the best way to put it. But they came up with an entirely new concept in their marijuana law to create the inception of a WIRE, a workplace impairment recognition expert. And it's essentially someone that should be trained on how to recognize the signs and symptoms of drug use. Well, New Jersey is kind of scrambling a little bit because they haven't created what the guidance is to become a WIRE or who can actually become a WIRE.
Yeah.
They pretty much have, as of this moment, advised for employers in that state to follow general training on this recognizing the signs and symptoms of drug use or reasonable suspicion training. So
Yeah.
we'll see how that concept kind of folds out there. But as you know, in law enforcement, you may or may not know that there are trained drug recognition experts that are trained to see if an individual is under the influence of drugs or alcohol. And that inception was, I guess, kind of converting over into the workplace here, at least is what New Jersey was trying to do. But
Yeah, it's going to be an interesting evolution of that concept.
you want to touch real quick on the two court cases there, Colorado, Nevada? Do you want to highlight just?
Yeah, what was interesting about these cases is individuals said that they were entitled to use marijuana because it was protected as an off-duty use of a lawful product. First in Colorado, it's known as the Coates decision involving Dish Network, and essentially the court said off-duty use, yes, we do have a statute that says employers can't discriminate for your off-duty use of a lawful product. However, we define lawful to mean both under state law and federal law. Nevada, just recently, in fact, the Nevada Supreme Court followed suit and agreed with the court in Colorado. So the employee who brought an action seeking protection for his off-duty use of a quote lawful product in Nevada was found not protected because, again, it was not lawful under federal law. Now, what's interesting about some of the new statutes that are being enacted, such as Minnesota, is when the section of the law says that employers can't discriminate for off-duty use of lawful products, it then goes on to say lawful under Minnesota law. And it's distinguishing itself in Minnesota from these kinds of decisions in Colorado and Nevada.
Yeah, and let's elaborate a little bit on Minnesota, Bill. So this new law goes into effect in a couple of days, August 1st,
Yeah,
which is
different
incredibly.
sections of it. Yeah,
Go ahead, I'm sorry.
different sections start August 1st. There's some sections that start January 1st. So you got to be specific about what you're looking at. But it's a very, very detailed state statute. And what it essentially does is the adult use of marijuana law merely amends or adds to existing drug testing statutes. Okay, so Minnesota has for many, many years, late 1980s, early 1990s, had a very detailed very detailed drug testing statute. So what's happened here is the adult use of marijuana law essentially creates new provisions or amends provisions of that very detailed drug testing statute. And it creates sections like defining what cannabis drug testing is. It adds cannabis testing to the drug testing law throughout. So you've got to really sit down with somebody and understand what exactly you're allowed to do and not allowed to do under the new Minnesota statute, like whether or not you can test individuals pre-employment for cannabis. There are safety sensitive exceptions. What safety sensitive is, it's been redefined. So if you're in Minnesota, you've got to be careful.
It's and pretty much every employer in the state needs to take a look at their workplace drug and alcohol testing policy. In fact, we'll just call it out right now for everybody that has a workplace drug testing program in place. You better have a policy and you better make sure that sucker is up to date, because there's so much of this laws, so many of these laws that have changed recently, just in the last 3 to 5 years, quite dramatically, that impact the workplace like never before. So if your policy is not up to date, you're already a leg behind.
I mean, this statute is over 300 and some pages long. Section 6 which is called the miscellaneous provisions sections of the law. That's where you'll find the employer sections. I'm sure most of you don't want to just go out there and read it. But if you look at sections 14 through 25, I hate to say I know this, that's where you'll find the sections that impact your workplace. And it's very, very specific about policy issues. In fact, it defines a cannabis policy section. So please make sure you go and take a look at it or call us. Happy to help you out with that. Very, very detailed stuff.
Yeah. So again, just to recap, for California, of course, prohibiting testing for non-impairing metabolites of marijuana effective January 1st. That's for all permissible purposes. Again, there's a safety sensitive carve out specific to the construction trade. And then Washington, where I sit here, pre-employment testing will be limited to non-impairing substances, excluding non-impairing substances. So requiring the use of showing Delta 9 as a positive for pre-hire. And there's a little bit more general of a safety sensitive carve out there for jobs that job functions that could cause death if impairment were in play in the workplace. So again, it's going to come down to what your policy states, what your procedure states, and how you comply, and hopefully try to take advantage of some of these safety sensitive carve outs, especially to continue screening for your safety sensitive employees. Bill, anything else on this slide that you wanted to elaborate on?
No, I think we've kind of beat this to death.
Excuse me. So we'll jump into the importance of job descriptions. And I kind of already led into this, but in order for employers to take advantage of those safety sensitive carve outs, you need to justify that your employees truly are safety sensitive. You can't just say and be like one of our past clients that said, well, I'll just consider all my employees safety sensitive. That's not a good defense when it comes in the court of law to try to prove, right? So
Well,
the-
actually, I'm sorry, Nick, there was a recent court decision, Supreme Court of Iowa, that basically was talking about the differences between the safety sensitive nature of a particular job versus the environment, the job environment. And it was a warehouse, definitely a safety sensitive environment, but the court said you must define positions by position according to the jobs that they're going to do, not the environment.
Yeah, and there's a legal term here called the essential functions of a job, and it's written here. It's detailed in this slide, but essentially what it means is you as an employer need to define by job role what those essential functions of those job duties are, specifically what they are in terms of being safety sensitive. If they're in the kitchen, not everybody in the kitchen is safety sensitive, although they could be, because your potential for safety slip and falls, but they're probably dealing with knives, hot liquids. What are the tangible things? What are the in practical nature of what they're doing in their given day that they're required to do as part of their job that would make it safety sensitive? These details will be incredibly important if you're ever to be challenged in the court of law by trying to take advantage of these safety sensitive carve outs with the marijuana laws. By utilizing the safety sensitive exemption, you're going to be prepared to prove that in the court of law. So again, a call out to everybody on here to make sure they have job descriptions, make sure they're comprehensive, make sure you keep them up to date, make sure they're detailed by job role. All right. So we wanted to make sure, again, we talked about a lot, and I know this is only an hour conversation. We can probably spend several hours talking about individual situations, different states and all that stuff, but we wanted to make sure we left you with some tangible guidance and action items. And before we jump into that, I just wanted to remind everybody, OSHA sits over top of everybody's heads with the legal obligation to make sure that you provide an employment that's free of any hazards. Essentially, it's a safe employment for your employees and the general public. So that obligation is there as the general duty clause overarching everything that you do today. So you have an obligation to make sure your workplace is safe. With the increased public opinion on marijuana legalization, how popular the drug is, how the use continues to increase, whether it be medically or personally. We dealt with the pandemic. We dealt with everybody self-medicating. We're now dealing with remote workforces. We talked about the pandemic era labor shortages and employers trying to utilize that to maybe use marijuana as something they remove to try to attract different talent. Our best guidance here is to not put your head in the sand as an employer and just feel like stop testing for marijuana is going to solve all your problems. We saw earlier the post-accident drug testing rate by Quest just in the last year, over the last 5 years has incredibly climbed to incredible rates or something that definitely should be a cause for concern. There are also situations where employers must still continue to test for marijuana. As we talked about, with the federal laws, federal DOT regulations still require testing. If your company operates under federal contracts or grants, you most likely must still continue testing. There's things like unions and collective bargaining agreements that may play a role. And there's also workplace drug testing laws for employers that are voluntarily following those laws for some sort of financial benefit. A lot of those laws dictate that you must follow DOT regulations or mirror DOT regulations in your program, which of course would continue to mean you have to screen for marijuana. And federal level marijuana laws, there's state marijuana laws, and we even broke it down by municipality or local city level. So again, combine that with the different court rulings that we talked just briefly on and some agency decisions. All of those need to be considered in combination to make sure, Bill we talked about, there's other laws outside of marijuana. There's 32 states that have mandatory workplace drug and alcohol testing rules that just dictate what you can and can't do if you wish to conduct workplace drug testing. And there's case law mixed into that. So all these things need to be considered to make sure you have a compliant workplace drug testing program. And then the last point here, workers' comp benefits has been hotly contested. Bill, do you want to make a quick statement on that?
Well, there's a couple of things here. One has to do with obviously whether or not testing positive for marijuana means that you're excluded from benefits. If you're a medical marijuana patient, how does that affect you? And then secondly is the reimbursement costs for marijuana. If you're an employee who's been injured on the job and you've been advised that the use of marijuana may assist you in your treatment, does the employer have to pay or reimburse the cost of that? That is a growing area of concern throughout the country.
And states are essentially split on the topic, right? I mean, we see rulings on both sides.
Without question, yeah.
Yeah. Yeah, so it's very, very fascinating how like New Mexico requires employers to compensate for a medical marijuana patient's cost for their marijuana.
Yeah, but now they have a schedule at least.
At least, yeah. So, all right, so limiting your liability, that's what this conversation is all about, is being aware of the laws and limiting your liability. So first and foremost, we're going to recommend that you clearly understand the language of the laws in each of the states that you conduct business in. As you can see, these state laws differ greatly and may even differ by municipality, by city. We always recommend and strongly, well, I'll just leave it there. We strongly recommend that employers have a written drug-free workplace policy in place if they're conducting testing. Make sure that policy clearly states the company's stance on the prohibited use of illicit substances, now including marijuana also, and the related consequences that'll be imposed for policy violations. Definitely make sure you understand the laws on when you can test, what test methodologies you should be using, and of course, stay up to date with all the regulatory changes as these are happening at a far more rapid pace than ever before. Now, the policy document's one thing, it's a living document, but we all know that a lot of people don't look at the details of it. So almost most importantly is implementing sound processes and procedures that complement the language within your company policy. This is telling what your managers and your employees, what they need to do, what they need to abide by, and how to handle certain situations, especially what action steps to take in the heat of a moment, like a post-accident test or a reasonable suspicion situation. Having that documented to a T is incredibly important so it doesn't leave any gray area for someone to potentially do the wrong thing. We've talked about it earlier in the presentation. I'll say it again. One of the single best investments you can make for your company is to invest in training, providing your managers and supervisors with training on how to recognize the signs and symptoms of drug use, what the details of your substance abuse policy is, what the procedures relate, and what action steps they should take in these situations. Make sure that you document and routinely review your job descriptions. And this is, again, for each role within your company. Especially for those roles that you're going to be classifying as safety sensitive, whether you're utilizing that to take advantage of a state marijuana law or not. You will need to be prepared to defend your stance in the court of law if you're ever challenged. And then finally, be prepared to engage in an interactive conversation for medical marijuana patients to determine if their underlying medical conditions can be reasonably accommodated before you take any adverse action for those employees. Now, it's a requirement in some states' laws. I think this should be adopted as a general practice, regardless if it's a case law or mandatory law in each state. So, as we promised, we wanted to make sure we left some time for Q&A. Ryan, do you want us to start looking at these real quick and addressing this?
Yeah, please do, Nick. I only need a couple minutes at the end, maybe 3 minutes to close us out. So please take the next 9-10 minutes and address as many as you can.
Excellent.
Yeah, by the way, if we don't get to all the questions, we will answer them.
So a question, does the increase of THC positive mean that associates are intoxicated at work? So again, we don't have, the science hasn't caught up here. There literally is no method today that shows someone's indicated at work or intoxicated at work under marijuana. Now, excuse me, with oral fluid testing, it is the best method in our opinion to detect recent use of marijuana.
Right.
So it gives you a better idea. That combined with potential signs and symptoms could get you there, but there's no product on the market today that actually shows impairment or intoxication.
And that's really important. What you just said there is really important because even though the statutes refer to under the influence, they also start out by saying used at work. Okay. Well, oral fluid testing gets you the closest to that at work item, which may allow you to take adverse action.
it's an important legal threshold to determine, right? If someone tested positive in an oral fluid test, I think we had it, what, 2 to 12 hours, Bill?
Yeah.
That shows that they used recently. It didn't show that they may have used 3 days ago and that it was just
Yep.
a fat soluble, positive that they're
And
carboxy positive.
combine that with the fact that we know some folks that are doing studies and work on oral fluid testing, they know that they can pinpoint use within 3.5 to 4 hours. Okay, that fits within your window of detection for potential for impairment, but certainly for use.
Yeah,
Yeah.
I'll just name it, just a quick name drop here to Buzzkill Labs. They're working on an oral fluid solution that actually can detect. They're bringing a whole different level of an instant test to the market that actually has lab comparable to lab-based testing. But a very exciting product. Again, there's several others out there that are trying to solve this problem, bringing in cognitive, articulable tests, some vision tests, and all kinds of different apps to use to determine impairment. And again, we throw caution to the wind there because a lot of these haven't been challenged in the court of law, so we have no idea how they're going to apply. But the workplace industry is desperately waiting for the perfect solution provider to come to help us solve that problem, but it doesn't exist today.
Yeah.
Bill, can you do pre-hire testing based on a positive? Based on position. So if an office position doesn't have pre-hire testing, but safety sensitive positions do. Can you craft testing based off of position?
You can, but you got to go state by state and look at the definitions. What is safety sensitive? There are many states that define what safety sensitive is. And then there are states and other jurisdictions, cities, et cetera, that limit or prohibit pre-employment marijuana testing. So it depends on where you are.
And I'd also caution to you that make sure that you apply these rules across the board fairly and consistently. So make sure you're not making any exceptions by individual, but basing it off of position, because you can absolutely open yourself up to a potential discrimination suit there. Let's see here. Can California employers still test non-DOT regulated employees that are in safety sensitive, such as heavy equipment operators?
Well, it was what was it, Nick? How did they phrase it? The construction industry that was excluded from the new law that takes effect January 1st, 2024.
Yep.
Otherwise, every non-regulated employer is limited to action when they find a psychoactive component or metabolite of cannabis. Yep. Did you hear what I said? If you don't find Delta 9 or hydroxy THC, you can't take action.
Yeah. We have a public employer question. We can punt on this if you want, Bill, but in Minnesota after August 1st, a sworn police officer provided firearms. They still cannot use marijuana off duty because the firearm ammunition is correct. That may be a really specific.
Law enforcement officials are excluded from the new law as safety sensitive positions.
Please address the use of marijuana at companies governed by OSHA, which is a federal agency and federal agents.
I'm sorry, say that again. Please.
Yeah, so address the use of marijuana at companies governed by OSHA.
Well, every company is basically governed by OSHA to some extent, okay? And in some states, 22 states, the state agency, like in California, it's Cal OSHA. They are essentially OSHA, and they can have their own rules, so provided they minimally enforce the federal OSHA requirements. So I think what you're maybe getting at is the fact that in 2016, OSHA came out with a commentary related to post-accident testing, and their position was that you couldn't have automatic post-accident testing. Just keep in mind, in 2018, they withdrew that position. Okay, so you can have automatic post-accident testing. Be careful. In some states, you can't do drug testing post-accident, like Connecticut and some others, Rhode Island. You cannot conduct post-accident testing. You can only do testing in some states when you have reasonable suspicion. So be careful about that. I hope that addressed your question.
A great point, Bill, because that did kind of go back and forth for a while there. So they did finally land on this final stance. But let's see. Does California limit pre-employment marijuana testing? And again, the limitation there is testing for non-impairing substances, and it's for all reasons for test, not
Correct.
just pre-employment.
Yeah, the difference between California and Washington is California is all employees and applicants. Washington is just applicants.
Yep. You mentioned earlier that there have been an increase of more than 200% in positivity. Do we know if there's been any overall increase in accidents, even if we don't know if it was because of THC? And I'll just say that I think the science and all the data needs to align, because again, in accidents, we're still probably most likely testing for non-impairing marijuana
Exactly
metabolites.
right.
So
That's-
the data would be skewed in that point.
That's exactly right. And according to NHTSA, their latest study shows no appreciable indication one way or another related to increased marijuana use and accidents.
And just like alcohol, or very similar to alcohol, when they were starting to create the method to determine under the influence and impairment and the methodology and the correlation to accidents, that took decades. And I really see the same thing for marijuana, as it's even more complex, right?
And there is an enormous difference between cause of the accident and simple existence of the drug in someone's body who got involved in an accident. So there's a huge difference, and you've got to look at the studies that exist out there with very jaundiced eyes, I guess is the word.
Yeah. Yeah. So in Washington, just to elaborate, in Washington, can employers test for marijuana after an employee is hired for non-safety sensitive? So again, the prohibition in Washington is specific to pre-employment.
Mhm.
So employers can have a comprehensive post-hire testing process to include testing for marijuana. Doesn't have to be just for safety sensitive positions.
That's right.
Do employers not have an umbrella protection since federal law supersedes individual state law? What about the undue hardship for business and workers for workers' compensation? Bill, you want to take that?
Boy, that's a lot going on in that question. Well, first of all, federal law typically does preempt state law when they collide. And that means when they are colliding on the same issue, okay? But if they're not colliding on the same issue, and I know the word collide is a terrible word to use, but when they are addressing the same issue, then federal law preempts. If they're not addressing the exact same issue, then they don't preempt. So you can have what appears to be something addressing the same sort of issue when in fact they're found not to be. So you have to be real careful about that. Like for instance, in some of the early court cases in Connecticut and some other states, the question was, doesn't federal law preempt the state law so employers aren't bound by that? Well, I remember in Connecticut, for instance, the court said, well, not really, because the Controlled Substances Act deals with the person who uses the drug. And there's nothing that says that employers can't hire a criminal. I love that concept.
Yeah.
So,
We've got time for one more. There's a lot of questions in here. So again, we'll do our best to follow up with those individuals we didn't get to do live. But Bill, are we still allowed to do random drug testing in the workplace?
depends on the state. There are many states that prohibit it or limit it very specifically to safety sensitive workers. In states like Massachusetts and Minnesota, you can only randomly test those in safety sensitive positions.
Yeah. Okay, Ryan, I'll let
Get
you
it
turn
all
over
in
to.
Rhode Island or Connecticut. Forget it.
Yeah, that's true
Well,
too.
in Connecticut, if you get permission from the Department of Labor, yes.
State laws matter. State laws matter.
State laws matter.
Like you gentlemen said, we could spend the next probably day or so answering questions, interacting with the audience. Perhaps you both offer an 8-hour workshop. We can do an encore presentation sometime. But I want to say thank you so much to our speakers today, Bill Judge, Nick Hartman with Drug Screening Compliance Institute. Excellent information as always, gentlemen. For those still listening in, I'll ask for exactly 3 minutes or less of your time to share some important info and close us out. First, as you see here on the screen, I encourage all of you to let our speakers know how they did by completing this brief anonymous survey. I will attempt to, towards the end, paste that survey link in the chat. So once you see that, go ahead and click on it, share your feedback. If I'm unable to do that because of time constraints, that'll be sent to you in an email. Please share your feedback, your ideas, suggestions for future topics. We look at every single survey response that comes in, and trainings like this, webinars like this were created based on your request, your need. As promised, for credentialed HR professionals, here are the activity IDs. They will also be on your certificate of completion, which will be emailed to all attendees by the end of today. A copy of the slide deck linked to the recording will be emailed to all registrants by week's end, possibly tomorrow, so keep a close eye on your inbox for those. And in closing, if you enjoyed today's presentation, which I imagine you did, I know I did, but you have remaining questions, reach out to your local ArcPoint Labs. Now speak to one of our many experienced and accessible lab owners. They can answer questions and offer solutions on a variety of topics related to worker health and well-being, safety, productivity, like background screening, drug and alcohol testing, policy development, employee assistance programs, leadership, all staff training, the list goes on. Simply Google ArcPoint Labs near me and call the phone number listed or visit us on the web. A consultation request link will be included in the post-webinar emails that you'll receive, which is another way for you to reach out and learn more about ArcPoint services from your nearest ArcPoint Labs. And lastly, and perhaps most importantly, as Bill and Nick showed, their incredible knowledge, but also how complex this is and how so many responses start with, it depends. It depends on a lot of things. You will receive in that request link that you'll receive via email. That's the same link that you're going to receive, that you're going to use to ask for a copy of a marijuana state law guide. So if you business leaders who are wondering exactly what state law or state laws, the states in which you operate your business, to understand them a little bit better, I can't stress the helpfulness of this guide. Reach out, request it. You're also always welcome to stop by in person, visit any ArcPoint Labs, ask for that guide, other materials, meet the staff, learn more about our services. So with that, one last final thank you to our speakers today. Excellent information, gentlemen, Bill Judge and Nick Hartman. Thank you all so much for joining our webinar today, and we hope to see you at the next virtual ArcPoint event. Take care, everyone.
Thanks, Ryan.
Thanks all.